Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Heldt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
All right, welcome to today's podcast. I'm here with Jamie Hargrove, who is a founding member of the Hargrove firm, has started up another internet-based company, NetLaw Group, and is also doing a lot with elder law, has over 37 years of experience in estate planning and tax work. Jamie, welcome.
Thank you, Gary. Appreciate you having me on today.
So what made you pursue the career of being an attorney?
Well, actually, I didn't want to be an attorney, and I went to law school, but again, never wanting to be an attorney. I wanted to be a business guy like you, actually. And then I before that, I'd gotten my accounting degree, but never wanting to be a CPA. But after I got out of law school, somebody while I was still in law school, said, "Hey, you got an accounting degree. You ought to go into public accounting and get your CPA." Well, I sure didn't want to be a CPA, but it was a couple years, passed a few tests, so why not? So I did that, got my CPA. So now I'm a lawyer CPA, and I don't want to practice law, and I don't want to be a tax lawyer, certainly. And I had this lawyer in Lexington, Kentucky. I had about a 20-person firm. This was 1985. And he said to me, he took me out to lunch. He was actually quite famous in Kentucky. He was an NFL football referee part-time. So he's a prominent lawyer, and a guy by the name of Tommy Bell. Mr. Bell takes me out for lunch and looks over his glasses and says, "Mr. Hargrove, we've decided that we need a tax attorney for our law firm. And we've talked to several, and we've concluded we can't afford a good one. We want to talk to you." So my wife knew I didn't want to be a tax lawyer or a CPA, practicing CPA, and I went home and I was making $21,000 in an international public accounting firm, now Grant Thornton, and so I said to my wife after talking to them a couple of weeks, "Honey, I got bad news and I got good news." And she says, "All right, what's the bad news?" She says, "Well, the bad news is I think I want to be a cheap tax lawyer." And she says, "Oh, no. Well, what's the good news?" And the good news is they're going to double our salary. So I must say what I figured out pretty quickly was being a CPA and a lawyer, between you and me and your listeners, it really is nothing magic about that. But to the public, it sounds somewhat impressive. Again, it really just means I stuck it out in public accounting a couple of years. I took a test. No big deal. But it from a marketing standpoint, and that's what I really have a passion about, is I love marketing. I realized that, boy, there's something with this, and these firms that I've been with all these years have marketed me. And so I thought, what a great deal. So, and then I realized that, boy, there's a lot of, like with your practice, Gary, there's just a lot of people that need some specialty in their life that I could bring to the table. And so, and in estate planning, you deal with a lot of people, as you do in your practice, that have every day it's new, right? It's different needs. Sometimes it's financial, sometimes it's tax, sometimes it's just family circumstances that they're dealing with and a lot of times that's what it is. They kind of get ugly. And it's kind of fulfilling, very fulfilling, just to be able to kind of take all the broken pieces sometimes and put them together. And so it's a lot of fun. It's a fun just helping people.
Yeah. So, I mean, you're wearing a lot of different hats right now, with the different companies that you have founded and got going and everything else, and are having great success at it. But what is it that makes Jamie get up in the morning and, ready to really attack the day and want to do this?
Well, I am an entrepreneur at heart. So I like entrepreneurs and like probably a lot of your listeners that are entrepreneurs, they like to build things, right? And they like to see things grow. And they like to, they like quality. So, and so one of the things that I find each day is we don't have a perfect practice in any of the things that I've got my hands in. But I hope it's a little better this week than it was last week. And I hope it's a little bigger this week than it was last week. So I like building and growing, and that's really that gets me up. It gets me up and going.
Good. What so in going through, I mean, there's a lot of myths out there, a lot of things that people don't know, or they think they know, but they don't know. What is one of the biggest questions in your years of practicing and things that the clients aren't asking, but they really should be asking?
Yeah, I think probably the biggest thing is just the procrastination is the biggest challenge that we have in my business, and part of that is they almost don't know what to ask. To your point, they're and because of that, they just kind of put it off. And so and part of the putting it off is a belief by a lot of people, and sometimes that's fueled by the advisors themselves that's giving them some bad advice, is that for you to be able to really do good planning, you kind of have to give up something, give up control. If you're going to save tax, you got to give up control. If you want to protect your assets, you got to give up control. And that really isn't correct. It's if you do it right and with the right team, and it does take a team because even as I am very specialized in the estate planning space, I'm not specialized in insurance products, which are key to a good estate plan, and I'm not a financial planner. I'm an estate planner. That's different from a financial planner. So partnering with people like you, Gary, builds out the team, and with the team, then you can really assess what those clients need. And to your point, they really don't know what questions to ask. And sometimes we don't know until we really get dug in and start getting some good data, and then start us asking them questions that ultimately give them answers to their own questions.
Sure. So I know one thing that I hear a lot, and you can clear this up for us also, is, hey, I have power of attorney for my mom's stuff right now. So when she passes away, I'll be able to take care of everything. Does that power of attorney carry through after death?
It's a good question, Gary. And as you know, a lot of people think the answer to that is yes, or they just assume it is because, we'll get clients in and say, hey, Dad died, but here's his power of attorney, and I'm still paying his bills. Well, the only reason that works is because nobody knows, or the people that's accepting that power of attorney or those signatures, they don't know Dad's gone, because the power of attorney in all 50 states is void immediately upon the person dying. So then what, as you know, Gary, what takes over at that point is either a will, if there is a will, the executor that would be appointed, or if there is no will, you got to go to court and have an administrator, personal representative, depending on what state you're in, will be appointed. And so you actually have a gap between the death and that official appointment. So even though you might be named in a will as the executor or executrix or personal representative of that person, until you actually take that to court and let the court validate it and actually officially appoint you, you still do not have any authority to handle things. Now, most states do give you the authority, if you have that document, to at least make sure that you have protected and secured the assets. So, for example, you could go in and change the locks on the doors and make sure that family members or friends or whoever don't come in and start carting stuff off because the will and the other documents related to that may very well say things go to somebody else. So quite often in a family situation, the daughter says, oh, well, Dad wanted me to have such and such in the house, right? And only to find out that particular item is specifically referenced and given to somebody else, right?
Right.
And so who knows, right? So So those are the kind of things that, again, most people, if they do know it's the problem that you have in my business, Gary, is that when clients come in, even if they know all the answers, so I've educated them, I've spent maybe a few meetings and they've got this, right? Well, when they walk out of that door after they've signed those documents, they don't think another thing about that until some crisis comes up, which might be years later. Do you think they remember anything about that at that point? Absolutely, I wouldn't. So, and that's one of the problems that the lawyers have. You know, we lawyers think, well, it's actually not just lawyers; it's actually husbands and wives. You know, we say to my wife, for example, I've been married 37 years coming up next month. And I might say, you know, honey, I told you that last Thursday. I specifically said that. Well, and actually, it's probably just the opposite. It's actually, she probably remembers that. What happened was she told me something. Right. And of course, I was nodding my head. It looked like I was at understanding. I might have even halfway repeated something, but my mind was someplace else and I've long forgotten it, right? Well, our clients are the same way. And certainly when you start putting months and years in between that, they just don't know. So the part of your business and my business is kind of a continual re-educating and then re-educating them on exactly what they're going to need to do.
So another question that comes up quite often, it has to do with, you know, going into a nursing home and either having to turn everything over to the nursing home, or I have to give everything up where I don't have control of anything, any of my finances anymore if I do this. Is that, you know, can you enlighten us a little bit on how that, if that's true, not true, what we need to do?
Yeah, and Gary, that's a very good question, because it is a prevalent question, and it seems like it's coming up almost every day in my practice as I talk to financial advisors and investment people and insurance people. It's coming up every day in their practice, and of course, part of that is we've got this huge bubble of my generation that almost 10 years ago, they started hitting 65. They said about 10,000 people per day, right? Well, if you think about it, that bubble has been going from 65 to 75 the last 10 years. Well, when somebody goes from 64 to 65, not a lot of changes for most people. 65 to 66, not a lot of change. So going from 65 to 75 these last 10 years, we really haven't seen a lot in terms of just numbers of people going to the nursing homes. They're going there, but the mass numbers really haven't hit yet. But if you think about that big bubble, again, 10,000 a day now are not just hitting 65, they're now hitting 75. And now you got this for the next 10 years, they're going from 75 to 85. Well, you can imagine this is impacting a lot of people. And your question's a good one, because the perception is I've got to give everything away and lose complete control. Now, that is a solution. And the sooner you do that, the better. Now, there are negative income tax consequences to that, and there are other risks of that. So, for example, when we meet with clients, we will devise there's really two main plans that we do in the elder law practice. One is with a asset protection Medicaid type trust. If you just use the trust, you are going to move your assets into that trust. You're going to start a time clock that in most states is a 5-year look back. California actually is only a 3-year look back, for example. But in most states, it's a 5-year look back. And someone other than my client is going to need to be the trustee of that. And that may be problematic. If you're paying your own bills still and you're still active, my mom's 91 years old and she still drives, pays her own bills, etc. But what you can do is you can put assets in there that you want to protect from the nursing home that you're not necessarily needing to live off of. Or you can also do a different kind of plan where we actually put those assets into a family limited liability company. We actually let our client be the manager of that. We then move the ownership of that into our Medicaid Asset Protection Trust. And so even though it's a little more complicated on the front end, by the time the dust settles, what you end up with is our clients continue to pay the bills, do everything they were doing before. They're just doing it in a little bit different structure that now has started that 5-year clock. And at the end of that 5-year period, they're going to have the opportunity. They don't have to if they don't want, but they'll have the opportunity to let the federal government take care of their long-term care.
I think most people would think that that's very beneficial and be more than willing to hop on that. When looking at, I know lots of times what will happen too with people is that they will have their son or their daughter, whoever the oldest is, that's going to be who my executor is and so forth. I run into lots of times where the son or daughter is not real strong in finances and things like that, and they just have no idea what to do. Is there a way for the burden of this not to fall on a son or daughter that doesn't have the expertise to be able to handle this type of thing?
There is, Gary, and what you've described certainly comes up a lot, and probably the worst scenario is where you've got family businesses and you have maybe 3 kids, 1 kid in the business, 2 kids not in the business. Right. And what the clients will always say is we want to treat our kids fairly and equally. Well, when you got 1 kid in the business, I can assure you what he or she thinks is fair and equal is a lot different than the 2 that's not in the business.
Right.
The one that's in the business, they've got a sense, and it may be true, that a big part of the success of the business is because of them, right? And so to deal with that is really challenging. There's a lot of different ways to deal with that, but one of the things that we're seeing in more and more family business situations is actually the utilization of a private family trust company, because what you find is big trust companies and even smaller local trust companies tend to not want to be in the business of running your business.
Right.
That's kind of the last thing they want to do. The problem is in many times with family businesses, that's the biggest part of their estate. And consequently, they're in a situation where they don't want to cut their 2 kids out that's not in the business. But if your business is 80-90% of your estate, how are you gonna equalize that? So are you gonna leave them into some kind of non-voting minority interest, and that has all kinds of issues. Now, if we're at a point where we can do some planning and the clients are young enough and can qualify for insurance, my advice is to utilize insurance to help do that equalization. Right. So if the business is worth $2 million and that's most of your estate, how about getting another $4 million of life insurance? So maybe the business isn't going to grow as fast because you're going to pull some money out to fund this insurance. But hey, if you can get family harmony, give one business, give it 100% to your son or daughter that's running that, give the other 2 cash. Right. And cash is nice. So if you ask me if my I've got 2 brothers, and if the family business is going to one of them and my option is to get a minority interest in the family business or the proceeds of a big life insurance policy, I'll take the cash. And then I can go out and start my own business, right? Right. So that's really the best solution, is to try to avoid and eliminate, with proper planning and the right products, to eliminate that kind of a situation. But if mom and dad's 88 years old and they're still actually running the business, which we see every now and then, right? Then in that situation, it's some of these certainly voting trust. We use a lot of voting trust if they don't have quite the size of an estate to justify the cost of setting up their own family trust company, private trust company. Then many times we use voting trust and let the equity be shared according to however they want it to be shared. And then the voting trust can provide for that succession plan of ownership. But one of the things with that you have to be careful about in succession plans of businesses is that, okay, if my son, let's say, is running the family business, well, that's fine. I want him to have voting. And the reason we use a voting trust in that situation is, well, what happens when son dies?
Right.
Well, where do we want that vote to go? Do we want it to go to his wife? Probably not. Do we want it to go to his minor kids? No. So the voting trust says, okay, yeah, as long as son's there in the business, running it, then son, you can be the trustee maybe of that voting trust. But at your death or disability, we're going to change that up. And that voting trust allows us to do that.
So lots of times when we hear people talk about, the private family trust and things like that, I mean, are these only for the ultra wealthy? I mean, where does this kind of fall into play for how big my business needs to be or anything else, to think about putting into that?
Yeah, a good question, Gary. And historically, a private family trust company was certainly something that only the very wealthy people with $50, $100 million estates and larger would even consider. What has happened in the last few years is that states like Florida and a few others have actually created an unlicensed private family trust company. So it is a separate entity. It's a separate trust company, but it is unlicensed, which means that you don't have to go through all of the hoops that you would have to go through having your own trust company. So the cost has come down. It's still not inexpensive, but if you've got a family business that's worth, even if it's worth $5 or $10 million, let's say, what I find is one of the number one priorities for my clients, and many times, unless I pull it out of them, they don't actually come in and say this is my number one priority, but many times their number one priority is family harmony.
Right.
And the number two is the succession of the business. Well, and so if what the family private trust company can do is it can stand in between family running it versus a big corporate trustee running it. And so I've got something that's in the middle. So if it is a solution that actually delivers family harmony and business succession, and it may be the only solution that's going to deliver those two primary goals, then it's like, I think I need that, right? So,
Right.
So that's why, again, because the states have now eliminated some of the regulatory issues there, and the SEC has coincided and carved out some areas to allow for this. So it does allow for more streamlined approach, but it gives a real structure to that business succession plan.
Okay. You talked about family harmony. Another thing that I hear quite often is that, mom and dad have nice size estate, may have a business or whatever into it. Son's growing up and he's getting ready to get married. Mom and dad don't necessarily like the future missus. And their concern is, if we leave the money to him, and he gets divorced, she's going to get half of everything we gave him, and we don't want that. Have you dealt with this? How do we, get around this issue?
Yes, great question. And so probably since about somewhere in the early 1990s, I'm not sure, certainly in estates that have a business and have, $1 million or net worth above, I'm not sure I have ever set up an estate plan with sizable assets since the early 1990s that didn't have what we call a family protection trust.
Okay.
And it's to deal with the issue that you've just addressed, Gary, and it is very prevalent. And again, it's one of these issues that many times my clients don't come in and say on the forefront, when I ask Mr. and Mrs. Smith, why are you here? Right. Then they don't say I'm here to protect my assets from my son-in-law and my daughter-in-law. Now, there are a few cases where the son and the daughter-in-law are so bad that is the number one priority, but most of the time it's not. But when you ask the question, by the way, do you want to protect your assets from your son-in-laws or daughter-in-laws? And by the way, you may love your current daughter-in-law that you have, But with the long lives we live,
Right.
it's very well that your son will not die married to that one, and it may not be divorced. You know, she dies at old age, and he remarries twice thereafter, right? So
Right.
you don't know necessarily even who you're protecting those assets for. But what we do is we create that trust that's attempting to control from the grave. But what we do is we create really another gift. We have two gifts that our clients are giving their children. One gift is the inheritance. The second gift is giving it in a package, a structure that protects that inheritance.
Okay.
Well, who doesn't want to be protected, particularly if so when somebody comes in and says, my kids are responsible, I just want to give it outright. And a lot of lawyers will just stop there and say, great, then no need for a trust. But then if I ask the next question, well, Mr. and Ms. Jones, if I could leave those assets to your son and leave them in trust for your son, with your son having control and accessibility, and yet protect those assets from not only the current spouse, but future spouses. Oh, and by the way, protect those assets from maybe texting and driving incidents, driving and drinking and driving, estate and gift taxes that may come roaring back because of where our economy is now. Would you be interested in that? Well, when you ask a client that way, I've never had a client say, oh, no, I'm not interested in that.
Yeah.
You know, but you have to let them know what the option is. And the option is a trust that, again, is not designed to control from the grave. It's designed to give that son or daughter and family members the ability to protect that inheritance, but protect it in a way that they can still use it and control it.
Right. Right. Now those are some great points, because I know lots of times, in talking with clients and going through, hey, what do you want to have happen and so forth. Even when the kids are really young and they're still young, everybody, again, we all want to protect what we have because we worked really hard to get it. And that's why lots of times people come to me is to be able to save on the tax side of things. With that being said, can the asset protection trust help me avoid taxes when I go to sell my business in various states?
Yes. So, some states like Texas and Florida and Tennessee are no tax states,
right?
And no income tax. And that's wonderful. And if you live in one of those states and you sell your business, then you're not going to pay any state income tax. If you don't live in a state that has no state income tax, and so like in Kentucky, the state that our base office is in is a 5% tax. And most states are around, I think Florida, Indiana across the river from us is actually 4.2% or something like that, I think. And I think Illinois, if I remember, is 4.9 or something like that. So most hover around that kind of that 5% number. And there is these asset protection trusts can be utilized to actually avoid, in many cases, not all cases, but in many cases, avoid the state income tax on the sale of business. So if I'm selling my widget company for $10 million and I virtually have no basis in it because I started from the ground up with a $500 capital account, and now all the equity I built has been built as a result of its own earnings. So I have zero basis. I'm going to get hit with a $500,000 of state income tax and a couple $1 million of federal income tax. So $2.5 million. Well, with the proper planning, you might be able to eliminate that state income tax, which means I've eliminated 20% of my taxes on the sale of my business. And so $500,000, when you start compounding $500,000 for your future retirement or whatever your future plans are, and being in the financial services that you are, Gary, you add an extra $500,000 to those numbers compound a whole lot faster.
Oh, definitely. What about the testimonial charitable trusts and stuff. Do you use those very often, and what are the benefits with those?
Yeah, another good question, Gary. What we find with clients is really a couple scenarios. One is where we have clients that already have strong testamentary or charitable intent. So they might be giving large gifts away now, or they certainly want a big part of their estate to go to charity. Where we find this most often is with people who may not have children, for example. And if they don't have children, then they may have a much greater interest in and be much more plugged into giving their estate away to charity or larger portions. But even people that have children, we do have a lot of situations where clients will come in and say, you know, I've seen my friends that throw a lot of big money onto their kids, and it's not done well. I want to limit how much I'm going to leave the kids, and everything above a certain number I'm going to leave to my to the causes that are important to me. And in either of those situations, what we try to look for is, can we accelerate that gift, or at least the structure of that gift, so that we actually go ahead and make a gift today, but it's with a retained interest that would allow us to take advantage of some of the income tax savings that we would have by actually structuring that trust today. So, for example, the sale of that business you mentioned earlier. So let's go back to that $10 million business. Right. If ultimately I'm going to give most of that business away to charity, one of the things I may want to do is, let's say, take half of that $5 million. Now, on that $5 million, assuming I've already done my planning to save the state taxes, I'm still going to pay $1 million in taxes when I sell that 50% of that business. What if I put it into a charitable remainder trust? The charitable remainder trust sold that piece of half of that business. Charitable remainder trust doesn't actually pay any taxes. They reinvest the entire $5 million. So now out of that $5 million, I pay no taxes. I now have $5 million to live on for the rest of my life instead of $4 million. Well, guess what? $5 million produces more income than $4 million, right?
Right.
And what we find is that most people in that scenario, and you've seen it in probably more than I have because of the nature of your business, Gary, is people tend to want to live off their income. Mm-hmm. At least responsible people do, right? The generation that's the kind of the 60 and above, you don't touch that principal.
Right.
Well, if you're not going to touch the principal, wouldn't you want to have the principal be bigger if it could be? And it can be with that trust. And if it was going to go to charity anyway, then that gives you the opportunity to not only do you avoid that upfront $1 million of tax, but you can now buy and sell your assets as they grow. Because right now, and we don't do investment planning, and again, your practice gets into that a lot more from an advisory standpoint than we do, but one of the things that ends up happening inevitably is you pick a stock and it ends up being a really good stock, and all of a sudden you got a capital gain that you don't want to trigger. Right. And so you hold on to it probably longer than you should. Well, in a charitable remainder trust, not only do you avoid the capital gains on the front end, you can keep selling that and buying, and based on market conditions, not based on taxation, that you now can drive your investment, which again may grow that quicker, give you a stronger income for those retirement years.
Right. That's it's one of those ones where that almost sounds too good to be true.
That's right.
but again, everything that we've talked about so far, it just keeps going back to planning, and that's something that I harp with my clients all the time is we're here to help you write your tax future, not record the history. And really, when dealing with clients with preparing taxes and dealing with family members that have passed away, okay, now we're dealing with history, and we're just trying to report it and put it all in the right places as much as we can. And the planning part is the side that I see that is just so important. In if you spend the money now to do all the planning, it's going to save you so much on the back end. It's crazy, and sometimes it's hard to get through to clients about this.
Well, and it is, and that's really what I really love about your practice, Gary, and just the fact that you do income tax returns. One of the problems that I have in my practice is once the clients kind of do an estate plan or have that plan updated. Sorry about that. I know I lost the connection there. Once they kind of either do a plan or update the plan, it may be years before I see them. And so the beauty of your being in front of your clients on an annual basis doing those income tax returns is one, not only you helping them with their income tax returns, but you're there to spot planning issues. Right. And unfortunately, most accountants are not doing that. They're there for the task at hand, and the task at hand is to do the taxes, right? And so there's very few platforms like yours where you kind of got the goal really is the planning function, and what you're doing in terms of your income tax work and the other things you're doing are really just a means toward the bigger end of that planning, which, as we both talked about, is so critical.
Right. What, with all the challenges that we've had with COVID-19 and just kind of the way that things are moving, typically when people are doing estate planning and dealing with attorneys and everything else, we got to be in the office to sign everything, so somebody's there to witness, to notarize, and everything else. How is this changing? With what's going on, how is it from a legal standpoint? How is all this changing? And I know for us from a tax standpoint, IRS is starting to accept more and more the e-signatures and stuff like that. How is that now working with you and estate planning?
Good question, Gary. The most states now have an emergency order that now allows for remote online notarization, and even the remote online notarization has certain requirements in states that actually before COVID-19 came up, they were already allowing for remote notary and witness and remote signatures in wills and trusts in a very limited number of states. Today, most states have these emergency orders that effectively have said, look, if you need to sign a will and a trust, you can actually do that with your FaceTime on your phone. A lot of more and more lawyers are utilizing the technology you're using here, the Zoom technology or similar technologies, to allow clients to actually be in their homes and have everything witnessed and notarized, with the witnesses and the notary being in the lawyer's office. And what we're doing actually in my practice, there's 4 leading remote notary companies out there. We're working with the founders of one of those companies now to actually implement this as a permanent, ongoing part of our practice, so that we'll be able to, even after COVID-19 rules are relaxed, that we'll be able to continue to offer a remote online notary process. Because people are, even when this subsides, sure, people are still hesitant. And also they realize that if they've done it once before, what's the big deal about me doing it again, right? So we're kind of gearing up to be prepared for that next round. And I think you'll see more and more attorneys, hopefully, will be doing that.
Great. What have I not asked you that you want to kind of tell our listeners about? I mean, we've talked about a lot of stuff, and we could probably go on for another 4 hours. But what is it? What haven't I asked you that you really think that is important for our listeners to know about? Besides how to get in touch with you so they can, get some of the elder law and estate planning done.
Right. So, well, you've asked some great questions, and I appreciate the opportunity to be with you, Gary. I think the big thing, and we both emphasized it a lot, is get the process started and make the call. I work out I started with a program some years ago called P90X, mm-hmm. and the guy that kind of is your online host of that is what he always tells me is just push the play button, right? And the play button here is call Gary, right? And just get the process started, because whether it's healthcare documents you needed, what we find is there are most people, they think, oh, I've got a power of attorney. Well, most powers of attorney, some do, but most powers of attorney don't cover healthcare decisions.
Right.
Which means you're going to a hospital. Who's going to make your healthcare decisions? I mean, one of the things that the law gives us is the law gives us control over our own healthcare. If we don't take control of that, though, take charge ourselves by having healthcare documents created, prepared, and accessible, then what happens is someone else is going to take over that responsibility. It may be some family member that you really don't want making your decisions. It may be the hospitals or the doctors that are making those decisions. So that's one key component that virtually impacts all of us. And it's amazing how many people do not have those documents. And if they do have them, they can't find them, or they're not current and up to date. And related to that are just your end of life decisions. What do you want to happen to you in an end of life situation? Do you want to be put on machine equipment? Do you want to die in a hospital? Do you want to die at home? Those are issues that should be discussed among your family and then documented with some critical end of life documents. That's important for all of us.
Sure. So, Jamie, I gotta thank you. I mean, this has been great. I think we've definitely learned a lot today. So I really appreciate you joining us today on our podcast.
Thanks for having me, Gary. Yeah,
So,
it's been great.
Again, today my guest has been Jamie Hargrove, founding member of Hargrove Firm, NetLaw Group, and Elder Law. And we're definitely going to be talking to Jamie again soon. Thank you.
Thank you, Gary.
This show has been produced by Market Domination, LLC. To discover how you can have your own show completely done for you and turn it into a real published book and become the authority in your marketplace, go to www.marketdominationllc.com/podcast offer.